Now, we have the pleasure of having Mans Jacobsson, no need of presentation, former director of the International Oil Pollution Compensation Fund. Mans is going to entertain us on the strange circumstances of how the French Court of Cassation has dealt with the Erika case. Some of us know, some of us don't. It's a very interesting story. Please.
È per me un grande onore essere stato invitato ad intervenire a questa conferenza che ha riunito un così gran numero di illustri e eminenti avvocati italiani e stranieri. I think it's, in view of the lack of time, I think I better continue in English. Erika incident, I think, is well known by most of you. The ship broke and sank off the coast of Brittany, caused massive pollution of a large part of the Atlantic coastline in France, necessitating extensive cleanup operation at great costs and causing significant damage to the tourist and fishing industry. Claims were basically submitted under the international regime based on the 92 Civil Liability Convention and the Fund Convention. Most of these claims were settled out of court. Some of them, which had been partly or in total rejected by the shipowner insurer and the 1992 International Oil Pollution Compensation Fund, were brought to the civil or commercial courts, but all this litigation is now finished. But there was also a criminal strand to this. Criminal proceedings were brought in the Criminal Court of First Instance in Paris, and a number of parties joined in these proceedings claiming compensation, as can be done in French law, governments, regional local authorities, and associations protecting the environment, some 400 million euros. Now, this case went via the Court of Appeal up to the Court of Cassation, which held the following 4 persons criminally liable: the representative of the registered owner, the president of the management company, the Italian Classification Society, RINA, I regret to say, and Total SA. In addition, the Court of Cassation, also agreeing with the lower court, held these 4 persons civilly liable for the pollution damage jointly and severally. And I will only deal with 2 issues here: the channeling of liability and the compensation for environmental damage, because I think that for the industry here, that is where the problem of this judgment lies. Now, the Convention contains a very clear channeling of liability principle. So the liability rests with the registered owner alone. No compensation may be brought against the registered owner outside the Convention. But in addition, there are also exclusions for claims against other persons, namely the list you have in front of you here: servants or agents of the owner, the pilot and any person performing services for the ship, charterers, managers, operators, salvors, etc. But that protection doesn't apply if the pollution damage resulted from the personal act or omission committed with the intent to cause pollution damage, or recklessly and with knowledge that pollution damage would probably result. Now, what did the Court of Cassation say? It said that the channeling provisions in principle covered first the representative of the registered owner as agent of the owner, not very surprising; the president of the management company as agent of the operator, in my view, not very surprising either; Total as charterer. Well, that is, of course, a little more debatable, because in fact, Total was not the charterer. The charterer was a subsidiary company. The Court of Cassation didn't explain how it arrived at this. It appears that it actually more or less neglected the legal personality of the subsidiary company. But as I see it, and I think more people in the room agree with me, the interesting point here is that of the Classification Society. Now, what I'm going to say, I know my old friend Francesco Siccari won't agree with me, but I'm sure he can speak for that for himself in a moment. The Classification Society, it was said by the Court of Cassation, was covered by this provision as any person who, without being a member of the crew, performs services for the ship. And in my view, the correctness of the court's position here can really be questioned. As a matter of fact, I chair the diplomatic conference at which this provision was adopted. And in my view, it was never the intention of governments to go that far. They knew very well that the nuclear conventions contained total exclusion of claims against all contractual parties, and that was not a route that the conference wanted to follow. Because if you follow the line of thinking of the Court of Cassation here, any person being in contractual relation with a ship owner should be protected. For example, a shipyard or repair yard who negligently has made a fault repair which then causes pollution. There are several other reasons why it doesn't cover classification society, in my view. Firstly, performing services for the ship, I consider must be the operations of the ship. And it also, looking at the text, it should only relate to individuals and not to companies. And there are a number of other reasons, but I will not have the time to go into them. But in French law, obviously, the Court of Cassation has decided. But then the court said, well, after all these faults are covered, but they are not entitled to protection here, because they have all behaved recklessly, with knowledge that pollution and damage would probably result. And in respective the ship owner and the president of the management company, that was due to a lack of proper maintenance leading to general corrosion of the ship. For RENA, it was said imprudence in renewing the classification certificate on the basis of an inspection that fell below the standards of the profession. I apologize for saying that to the representative of the RENA here. Total, because of imprudence in carrying out its vetting procedures. I mean, here, of course, this is a matter of appreciation, what kind of behavior is reckless. And I think for the two first, as they were individuals, the Convention requires that the recklessness must be the personal act of the defendant. And they are individuals, so that's fine. But in RENA and Total, they are not individuals, they are companies. So it must be the alter ego of the company, the top management. And the Court of Cassation, with all respect, does not in any way explain how it arrived there. So you can really ask themselves, why did they reach that result? And I think that this probably means that the protection of the channeling is perhaps less valid than we thought it was. But worse than that, this test for breaking the channeling right is the same as for breaking the right of limitation of the ship owner, which means that if one takes the very strict approach of the French court here, perhaps the right of limitation under the 92 Civil Liability Convention and the 1976 LMC is much less solid than has generally been thought. The other question, environmental damage, and that is perhaps politically more sensitive. The Convention defines pollution damage as loss or damage caused outside the ship by contamination. But then there is a very important proviso saying that compensation for impairment of the environment, other than loss of profit from such impairment, shall be limited to a cost of reasonable measures of reinstatement. So admissible claims are only two: loss of profit resulting from damage to the environment and cost of reasonable measures for reinstatement. No compensation for non-economic environmental damage. No compensation based on abstract quantification using theoretical models. No punitive damages. And the provision was drafted exactly to avoid the problems that had been encountered in the old Fund Convention, where state courts to some extent ran wild. What did the Court of Cassation do here? Well, it awarded compensation for environmental damage to local and regional communities and to individual environment protection organizations. And what did they award it for? Ecological damage, loss of image, moral damage, and damage to reputation. And it appears that the court said that it would be sufficient for the pollution to touch the territory of the authority or the association, for making it entitled to compensation for all direct and indirect damage. Very far-reaching. So you would of course say, of course the court broke here the treaty obligations of France under the 1992, but not so fast. The court did award compensation for pure ecological damage. The damage was not documented. There was no proof of any damage in addition to what was already covered by other claims, clean-up, loss of income in tourism and fishing. And the damage could not be quantified except, as was done by the Court of Appeal, by using a theoretical model. But the snag is here, that the judgment was not against the registered shipowner. And the Convention only applies to the liability of the registered owner, since the four parties had lost the right of channeling. They were then subject to normal French law of torts. So at least on the face, at least formally speaking, I don't think one can say that the court decision here was in breach of the Convention. Another question is, of course, is it in following the spirit of the 92 conventions? And there I think one can really put a big question mark on what the court did here. And I think that is the danger is here, of course, that by this judgment, the courts can create a parallel compensation regime which could undermine the, as I see it, fairly successful regime under the 1992 conventions. Now, what will happen in the future? Will the French courts accept even claims for pure environmental damage if they are brought under the conventions against the shipowner, the insurer, the fund? Well, in that case, in my view, it will be a clear breach of the convention. And the states parties to the convention, including the French state, has emphasized the importance of uniform application of the conventions and insisted that the national courts should take into account the decision by the fund governing bodies as regards the interpretation of the convention. And we also know that, as regards France, a treaty ratified by France becomes an integral part of French domestic law. And such a treaty then has a higher rank in the constitutional order than normal domestic legislation. So if there is a conflict between the convention and the normal domestic law should give way. So here I can see great problems which could cause political upheaval in the international compensation system. What will happen in the future here? Well, during a revision exercise that was carried out within the fund 2001 to 2005, the question of extending the definition, widening the definition of pollution damage to cover also abstract damage to the environment, there was very little support for that. But of course, in the long run, these conventions will be revised. Law is not static, should not be static. Law must be adapted to changing circumstances, changing political, economic, social priorities. So like national laws, convention will have to be revised as time goes by, although of course it's much more difficult to do it because you first have to have compromises with over 100 states and then you will have to get it ratified. Well, when the next revision starts, it will not be this year, it will not be next year, but it will happen eventually. I'm sure that the question of environmental damage will come up. But the question is then, are the states prepared to extend the convention to cover also pure ecological damage, for example, in the form of violation of collective interest? Well, I don't know, but the only thing we know that it costs, somebody will have to pay for it. There is no such thing as a free lunch. And if you extend the compensation rights, the defendants will have to pay, in this case, the shipping industry, the insurance industry, possibly the oil industry through the fund. But that will, of course, in some way filter through to the consumer, at least in the ideal world, where the consumer will get this baked into the price. So the question is here a political one. It's not a legal one. It's a political one. How far are governments willing to go here? Thank you.
Thank you very much, Mans. For sure, France is not the best place to have a pollution these days, isn't it? I'm sure that our friends from the